everyone. It's 7 o'clock, so we're going to start right on time because we have a lot to try to cram into this hour. Welcome to our webinar on executive powers at the court in October term 25. Thanks so much for joining us after a long day. We really appreciate it, and we'll jump right in. I'm Kathy Ruffing. That's my very long title, but descriptive. I taught in Fairfax County Public Schools for 27 years, and now I've been at Street Law for 7.5 years. And I'm going to be your main host today. We have Emma Progar with us. She's our program manager. She's going to be manning the chat and the Q&A. And we have Gregg Nunziata with us, and I'll introduce him more in just a moment. We also have Ben with us, who is on our communications team. He's going to be mostly behind the scenes, but if you have a tech issue, please reach out to, it's going to read Street Law webinars on your in your chat. We're Street Law. You probably know of us or you wouldn't be here, so I'm not going to go on too long about this, but our mission is to advance civic and law-related education. We are nonpartisan, nonprofit, which leads me to our disclaimer that Street Law is a nonpartisan organization. The views shared by our guests are their own, and this program is offered for educational purposes only. Kim Whaley was going to be with us tonight, but she had a family emergency. So I'm sure probably every teacher on this call has had a guest speaker not be able to make it last minute. Unfortunately, this happened tonight. She's wonderful and we will miss her. But we are in the very capable hands of Gregg Nunziata, who is a friend of Street Law and has worked with us a lot. Almost every summer, he is a guest resource person at the Supreme Court Summer Institute. So he's going to be our guide tonight through this topic of executive powers at the Supreme Court. So Gregg is currently the executive director for the Society for the Rule of Law, and I'm going to let him describe what that organization is instead of me doing it. But you can see that he's been head of a lot of other organizations. He appears very often on national news to talk about all sorts of issues around the rule of law and executive power. And he has also had roles as a Senate staffer in the nomination and confirmation process. So Gregg, I'll throw it over to you to say a little bit more about yourself and particularly tell us a little bit about the Society for the Rule of Law.
Sure. Thanks, Kathy. I'm really happy to be here. As Kathy said, I've had the opportunity to participate in street law programming now for I think almost 20 years. So it's I think this is a great organization, and I really feel honored every time I'm asked to be part of something. And I'm very sorry that Kim isn't with us tonight. She's fabulous too, and I hope if you see other programs with her in the future, do seek them out. She's also written a series of books that are really, really accessible. I think even to high school students, but certainly to teachers about kind of what the Constitution is and different parts of the Constitution in real layman's terms. She's fantastic, and her books are fantastic. I'm a lawyer. I spent about half of my career in public service in a variety of ways, and some of my time, the other half of my time in private practice at law firms. In public service, I've worked at the Justice Department. I've clerked in the federal judiciary, and I spent probably altogether 12 or 13 years in a variety of roles in the Senate. And almost every role I had in the Senate played some role or in judicial selection, nominations, and confirmations. In particular, I was the chief nominations counsel over the Senate Judiciary Committee for several years and worked on the confirmation process for most of the Supreme Court justices who are sitting now, either at their Supreme Court confirmation or at their appellate court confirmation. So I know many of them well and have followed the court closely for years. The Society for the Rule of Law is an organization I run. We were founded a little over 2 years ago. We are a group of right of center, so conservative, libertarian, and center right lawyers who prioritize the defense of the Constitution, the rule of law, and American democracy above our partisan or policy preferences. And I'm going to try to do that today. I have certainly views on a lot of these things, but I'm trying to give you my fairest objective read on all of this. But if you want to ask me questions about some of my particular views later on the Q&A, you can. But so the Society for the Rule of Law does mostly educational programming, kind of like this. We do a lot of webinars and debates. We try to make them accessible to non-lawyers. You could find all of our content on YouTube. Both our public events and our webinars are up there and available anytime you'd like to see them. And we also do some advocacy work, some amicus briefs, and have filed some in the cases we'll be discussing today.
Awesome. The Q&A will be open the whole time. So please, as you have questions, as they pop into your head, use the Q&A to put them in there. And some we may be able to answer sort of in real time. But otherwise, Greg and I are going to make a real honest effort to get us to the Q&A with a lot of time to be able to handle those questions. So I'm going to start by just briefly showing you this visual of what we mean when we say October term 25. I think it's a little confusing of a term because almost all of October term 25 happens in 2026. So it can be a little bit of a misnomer. And so we'll start with this graphic. So the court always begins on the first Monday in October, and that's where it gets the term. So this term started in October 2025, and that's the day that oral arguments begin. So you could actually sort of make the argument that the justices have been back and starting their work before that, but that's what we consider the beginning of this term. So that's when oral arguments start. They happen through April-ish. Decisions start about now, sometimes earlier, but there's been 2 decisions handed down from the merits docket. And if you're not familiar with that term, we'll catch you up on that term in just a moment. 2 decisions handed down in just the last week. But everything else is still pending. Those decisions will be handed down until late June, maybe sometimes even early July, although I think the justices really like to be on vacation by then, but it's happened a couple times recently. And then the justices leave for the summer. The clerks are still working diligently, dealing with petitions for certiorari or people asking the court to hear the cases. The court comes back in late September. They have a conference, and then they start deciding, which cases they're going to put on the docket for the rest of the term. So that's October term 2025. So we are well into it here, as you can see the January 2026 on your graphic. Okay, so the first thing we want to ask Greg is we're here to talk about the cases this term, both on the merits docket and on the shadow docket. Again, we'll catch you up on those terms in a moment. But where we can find those powers in the Constitution. So these are only three clauses where most, if not all, of the cases from this term, we're going to look to these to see if the president has the power. So starting with the vesting clause, Greg, do you want to tell us about these clauses and what kind of powers emanate from them?
Well, what kind of powers emanate from them is maybe the whole conversation we're going to have today.
Right.
But if you look at the Constitution, this is it's very interesting. Our politics today are so focused on who holds the White House. But Article 1, the first article, is about the powers of Congress, and that's very long. And it's if you were a stranger to the American system, you would think Congress is where all the action is. It goes on and on about all the powers Congress has. The portion of the Constitution that talks about the powers of the president is Article 2, and it's much shorter and somewhat, other than it's specific about his ability to nominate people to fill particular offices and that sort of thing. But in terms of his powers, it's pretty vague, and we're going to go over them here. I mean, it vests the executive power in the president. And a lot of debate today in politics and constitutional law and at law schools is about what even does executive power mean? We know the president has executive power, but what is that? Is it merely just carrying out essentially instructions from Congress, or is it something broader? And I think legal scholars and certainly politicians have varying positions on that across a pretty wide spectrum. And this Now, the appointments clause and some of the cases that we're going to talk about today also flow from that. And I said it was a little bit more specific on this. The president fills these offices in the executive branch and these senior offices, what we call officers of the United States, also judges and ambassadors, are named by the president in the first instance. He nominates them, but of course, as you know, they are only seated after the advice and consent of the Senate is received. And that was once my job in the Senate, and I'm happy to talk a little bit more about that process if people are interested in that discussion as well later. And the take care clause. Again, a lot of constitutional law revolves around this too. The president is meant to take care that the laws passed from Congress are faithfully executed. And what exactly the scope of that obligation is, uh, uh, again, can fill debates and books.
Great. So, one of the things that teachers might hear banted around is this term unitary executive theory. It's in the press a lot these days. A lot of people are talking about it. It's certainly has a large role in what we're going to talk about the rest of today. So this term might come up often. So can you just walk us through the unitary executive theory? And I think that you also just sort of gave us a preview of the fact that this might mean a lot of different things to different people. So maybe the root of it that everyone could agree on, and then also perhaps what there might be disagreement about what that unitary executive theory entails.
Yeah, let me try to do that. And it is difficult because this is a phrase that's used a lot. And there's, I think, both good faith disagreements on what it means, what it implies, and also some just misunderstanding of it. But it's helpful to have it in the back of your mind and to think about all the cases we're talking about today. Before I get to the theory, let's put it this way. There's I think broadly there's two kinds of questions about executive power. And those are vertical and horizontal. And by vertical, I mean the power the president has over all his subordinates. So over everybody who works in the government reports up to him. How much power does he have over, that's the executive branch? That's vertical power. Horizontal power is how much power he has in the checks and balances and fights he might have, or someday she might have, with the other branches, with the judiciary and Congress. Okay, so and I think there are cases before the court this year that fall much more into one category or the other. So the unitary executive theory purports to address just that vertical power. And it claims that, as we saw, the Constitution says the executive power is vested in the President of the United States. What we mean by unitary executive is only to say there is just one executive, and the Constitution appears to put all executive power in that person. So if you adhere to a strong unitary executive theory, you simply say that the president has virtually complete authority over the executive branch, and Congress and the courts can't interfere with that power that is fully vested in the president. Now you got to, so I think that's stated as plainly as I can. Um, People get the unitary executive theory certainly wrong, kind of in broad cases where you'll sometimes see it in the media where they talk about the president being able to just steamroll Congress being the unitary executive theory, and that's just wrong. That's not what it purports to say. But there's a category of blurry cases in the middle. I'm going to talk about some of them today. I think we'll get to these. I won't get to them in so many details. But if he has sole authority over the executive branch, can Congress pass a law with civil service protection saying you can't fire people just because they don't vote the right way, for instance? Uh, some a strong unitary executive theory will say, no, Congress can't do that. These people report to the president. He can do whatever he wants. Others would say, no, this is really more about the normal checks and balances. Congress can shape, how the boundaries in which the executive operates. So there's line drawing there. There's some fuzziness. And I think there are people who have weaker and stronger ideas of what a unitary executive theory means, but it is more traditionally associated with Republicans and conservative lawyers.
Okay, so we're going to talk. I said I would go back and talk about what it means to be on the merits docket. We're going to talk about, do an overview, a flyover of all of the cases that the court is hearing this year. These four cases you might have heard more about because they are on the merits docket. And what do we mean by the merits docket? These are the cases that are going through the court in the way that your textbook probably explains that cases go through the court, and the way that all of the landmark cases that you teach about went through the court. These are ones that somebody petitioned for certiorari. The Supreme Court considered it. They decided to take the case. The case was fully briefed, which means, both sides got to file, various briefs. Amicus groups got to file their briefs. The Supreme Court heard oral arguments on it. They took, months perhaps to decide it, and then it was fully there was a decision handed down, and full opinions were written so that people can not only see how the court decided, but the legal reasoning that they used to do it. That's the merits docket. At this point in time, the Supreme Court's only hearing between like 55 and 65 cases all term on the merits docket. So the fact that four are about executive powers is pretty significant. And these are the four. When Greg goes through and talks about the cases in categories, these will come up. Most of these cases have been argued or are about to be argued. So the first two have been argued. Cook is going to be argued next week, and Trump v. Barbara is going to be argued in the spring sometime. But we'll get into the substance of these cases a little later. Greg, anything else about the merits docket that I should have mentioned?
No, I think that's helpful.
Okay. Okay. The other cases we're going to talk about are on the shadow docket. And just like there are lots of different definitions, and even the term unitary executive theory maybe has a connotation, so for sure does whether or not you call this docket the emergency docket or the shadow docket. I'm going to ask Greg to do a real quick overview of what this is. It probably won't be satisfying because you could do a whole webinar on this. And in fact, we're going to do a whole webinar on this in about 2 weeks. So I will plug that webinar at the end and give you a chance to register, give you the link to register for that webinar if you're intrigued by the idea of the emergency and shadow docket and you want to learn even more about it. So this is going to be brief and probably not satisfy your interest in the shadow docket. Okay,
Yeah,
great.
I'll try to be really quick. Yeah, has become a hugely controversial question amongst commentators, practitioners, judges themselves, lower court judges. The term shadow docket is taken as pejorative. Some of the justices on the court get very prickly with it. They prefer emergency docket. They've got some other phrases they use for it too. But yes, it is an emergency kind of procedure before the court, where the court gives a kind of rushed interim opinion. So, if in all these cases that are happening now, just kind of broadly, someone challenges something the Trump administration is doing, and the lower court issues a ruling saying that government has to stop doing that thing, and the government wants to appeal it, they can rush to the Supreme Court on an emergency basis and say, lift this order saying we can't do this, and let us keep doing this thing in the interim, for instance. And then the court does this really quick decision, which is like a balancing test, which interim ruling would do more harm or more good, and some of that's informed by the likeliness of who they think is going to win at the end. And so that's that. And so we've seen this happen in a lot of cases, and we'll talk about some of them today. But so they are interim rulings. They're not final decisions, but they do affect kind of what the government can do as the litigation goes forward. And as you know, constitutional litigation can take quite a long time. So these interim rulings can really matter. If we're talking about like some of these cases with the government either spending or not spending billions of dollars, if the court green lights it or doesn't, that can have significant consequences.
Great. So this is just a list. Again, Greg is going to go through. We're going to talk about these in sort of categories. But this is just a list of the cases that are right now on the shadow docket that or emergency docket that deal with executive power. So you can see it's pretty significant. And we'll talk with Greg at the end about, how much this either is the same or differs from past administrations as far as the number of cases that are making it to the court on the shadow docket. But just a visual for you to see the list together. And now we're going to start breaking them down by category. Okay, so now Greg is just going to sort of we've lumped the like cases together, and Greg's going to give you sort of a higher view of these cases. And then if you have specific cases about questions about cases, you can certainly put them in the Q&A. But we just want to get a feel for what is on the docket this term about these kinds of cases. And then also, I'm sure you'll be thinking as you're looking at them, the difference between the cases that are coming up on the merits docket and the cases that are coming up on the shadow docket. So we're going to start with firing independent agency personnel and federal workers. These cases are really in no particular order, except that this one has the most cases of any category. So we've been hearing about this a lot this term. It's certainly a trend this term. So Greg, take it away with the firing of independent agency personnel and federal workers.
Yeah, so this is a huge category, and as I said, it'd be useful to be thinking about vertical power versus horizontal powers, and the vertical powers being the unitary executive theory is implicated in that. I think I should, and I said that strong unitary executive theory tends to be associated with conservatives and Republicans, and we have a court, the majority of whom are appointed by Republicans and considered kind of conservative legal thinkers. These cases that deal with the vertical power, as these do, the president trying to fire people who work in the executive branch or in independent agencies, I'll get that to that in a minute. There are a lot of these cases because this president is really pushing hard on this theory and is challenging kind of long-held assumptions. These are also the cases in which I think it's fair to say that most commentators expect the court will be most sympathetic to him for some of the kind of reasons I've suggested about just where people have been, where conservative legal thinking has been on executive power over the last couple of decades. I'll talk about just kind of go through each of these quickly. So, first, independent agencies, what are they? Uh, they are, I think it's fair to say, a constitutional anomaly. Sometimes we talk about this as the fourth branch of government. There are all these agencies, the FTC, the FCC, the SEC, all this alphabet soup in Washington, who have been thought to be independent because they have statutes that create some degree of independence for them. They typically they're typically run by a panel, and that the statute requires that that panel, that board, or that commission has a significant representation from the party opposite to the president. So there might be three appointed by the president's party, and two have to be Democrats. And the way that works in our system is the Senate Democratic leader, or if the parties are reversed, the Republican leader, will pick the minority commissioners. And they can't be fired typically, except maybe for cause, for criminality or something like this, not for policy disagreements. Trump has taken the position, and the administration has taken the position that a scheme like that is basically unconstitutional because it interferes in the executive. It's Congress not allowing the president to control the executive. So this Trump versus Slaughter case is very deliberately kind of chosen and provoked by the president. He sent Rebecca Slaughter, who I used to work with in the Senate. She was counsel with me in the Senate Judiciary Committee across the aisle. The president sent Commissioner Slaughter a letter informing her that she had been fired because she did not support his policy views. The statute does not allow for that. You cannot fire the president, according to the statute, does not have the power to fire somebody like that. He's trying to say that the statute is unconstitutional and is bringing this to the court. And this would, if the court agreed with him, it would be reversing a case from nearly 100 years ago. Um, so that case, I think that the arguments happened in it. They didn't go well, it seemed, for the White House, and I think it's pretty likely that the president will win on that. Trump versus Cook is a different matter. That is the Federal Reserve Board, and it's different for a couple of reasons. One, just for practical reasons, lots of people are worried about the independence of the Federal Reserve Board. I mean, there's a kind of a strong view that we need independent monetary policy that cannot be politicized. So there's been a lot of work, and the Supreme Court has suggested it agrees with some of this legal work, trying to carve out the Federal Reserve as being somehow different, having a different pedigree that allows for Congress to protect it from presidential interference more than it could with other agencies. But secondly, and importantly, at least so far, the Trump administration is not challenging the independence of the Federal Reserve. It's not making this argument that it could fire somebody for any reason. The president's claiming he's firing Commissioner Cook, the board member Cook, on the basis of cause. He's saying that she had committed some fraud in a mortgage document or something like this. So they're not trying to challenge the statute. They're trying to fire her for cause. So it's not quite a unitary executive case, and it may come out differently, I think, than Slaughter. The shadow docket cases are Trump versus Boyle is much more like the Slaughter case. Blanche versus Perlmutter is a little bit different, and this is I don't want to get too in the weeds on any of this, but it's interesting because under current law, the person who runs the Copyright Office, this is something of an anomaly, works for the Library of Congress and works for Congress. So it's an office that seems to be executive, but has always been kind of lodged in the Congress. So it's not an independent agency case. And there's some different kind of separation of powers concerns there. So that'll be an interesting one to watch that may be in a totally different track than some of these others. I think I probably gave you more details than you needed on that one. So let's move forward. Impoundment of appropriated funds. This is, I think, a big category, and we will should be watching it closely. This is much more of a horizontal power question about the struggle between Congress and the president that's embedded in our Constitution. I think it's pretty clear, as I said before, that the court is likely to agree with the president on a lot of the vertical power cases. I think there's much bigger questions about where they'll come down on some of these vertical power cases. Um, Impoundment is when the president chooses to not spend money that Congress has appropriated. You know that one of Congress's biggest powers is the power of the purse. It directs how the government spends money and what it does. Presidents in our history have tried to simply not spend the money that Congress tells it to spend. If Congress establishes some program, funds some program, the president doesn't like that program, a president might just say, not going to spend the money. I'm not going to execute that law. And so here we have questions about, is that taking care that the law is being executed as he's meant to do under Article 2? There have been a few controversies about this in our history. President Nixon was aggressive here, and Congress responded by passing a law called the Impoundment Control Act, which really tries to limit the ability of the president to do this sort of thing. Uh, this White House and a lot of senior advisors in this White House have believed for some time that law is unconstitutional and that the president has some inherent Article 2 powers to simply not spend money if he believes it's in the service of the United States. This sounds pretty black and white, but there's some degree of gray here. I mean, I think it's understood that if Congress passes a law that says, the president must buy a boat for $100 million and he's able to get it for $80 million, he can do that, right, and save the government money. Or if they pass a law for the president to, the government respond to some disaster that was expected that never materializes. The money doesn't need to be spent. But if he's just holding back money for policy reasons, for disagreements, that really does seem like a violation of his obligations under the Constitution and like something that is undermining the Congress's core power of the purse and appropriations. But these will be very, very interesting cases and very important cases. And
There's a question in the chat in the Q&A, and apologies to those people who I've seen their questions after we've gone to the next topic, so we'll hold them for the Q&A. This one I saw while we're still on the topic. So this question says, I'm paraphrasing, isn't impoundment of appropriated funds not a de facto line item veto retroactively? Did not SCOTUS previously prevent Bill Clinton for an attempt to use a line item veto? So I guess they're trying to draw an analogy between the line item veto, which is decidedly what the Supreme Court decided was unconstitutional, and this idea of impoundment.
yeah, no, I think so. I think it's very similar to a Lana veto in concept, and I'm personally again I'm trying to be I'm trying to be neutral here, I share that view, and I mean I think that I think depending on which case comes to them and on the specifics of a case, I mean I think the court's going to have some sympathy with Congress here. I think. Uh, if the president could simply disregard congressional spending programs at will for policy reasons, that would dramatically reorder the balance of powers in a way that I don't think this court is going to accept. But I've predicted things wrong before.
Okay, this one is hot on everybody's mind, of course, Trump v. Illinois. And this is one that it's on the shadow docket, and people keep thinking this decision is going to drop. And if you do the live blogs on SCOTUS blog, everyone's tuning in and thinking, oh, we're going to get a decision, we're going to get a decision, no decision yet. And so Oh, sorry. This one they have decided, but let's go ahead and hear about Trump v. Illinois. Sorry, I was thinking about the other one.
Yeah. No. Yeah. So this has been a big kind of. There are a lot of legal questions about the administration's use of military assets to carry out more or less routine law enforcement or immigration enforcement efforts in our country. And there's been different legal postures for different deployments they've ordered. You know, this has happened here in Washington, D.C., as well as in Chicago and some other jurisdictions. So Trump versus Illinois had to do with federalizing the National Guard for law enforcement purposes in Chicago. This one, I guess I should mention, the Society for the Rule of Law did do a brief on this one, and the decision in the case was largely came out the way we argued it should. So I have some bias here. But there's a general kind of rule, and there's a law in the books that the military cannot be used for domestic law enforcement. Uh, the administration, just in short, was trying to, instead of using the normal military, federalizing the National Guard to do things the normal military wasn't allowed to do. And the argument against this was that they were misreading the law to kind of create a backdoor to allow militarized policing around the country, which would have been open-ended. And the court basically agreed with that. Um, you know, the law here in question that they were relying on said that talked about situations where you could militarize you could federalize the National Guard when the regular forces of the United States were unavailable. And they were saying because it was illegal to use the regular forces, they were unavailable, so they could use the National Guard to do these things. And we argued, and the court agreed that was a nonsensical reading of the law there.
Okay,
Immigration is going to be a big area of litigation, I think, quite obviously. And things are just starting to bubble up. And here, we have a couple of these shadow docket cases. Immigration is probably an area where, um, the executive has a good chance of winning in a lot of arguments. I think typically our laws have been uh, more deferential to the executive on kind of matters of immigration and national security. And the administration is trying to frame a lot of the immigration enforcement as a question of national security. We'll see how they all shake out. There are kind of, we can call immigration a category, but there are really lots of different kinds of legal issues that are coming up under immigration. And these two examples are, you know, particular, I guess. The first one is about temporary protective status. So we that's a law that allows the government to kind of grant uh, it's exactly what it sounds like, a temporary status to people who would otherwise be unlawfully present because they come from countries that are in some degree of turmoil, which and it would not be safe for them to return right now. And the administration has been terminating these statuses that have been granted to various nationalities over the last several years, somewhat summarily. I think my guess is that the administration is probably going to do pretty well on these cases. There's a lot of just discretion in the existing law to the executive. I think in this first case, the main argument is that the president has terminated temporary protective status, not based on any kind of rational finding of the state of play on the ground, but based on essentially animus or prejudice against immigrants from certain jurisdictions. And the ICE case is also about allegedly prejudicial approaches to law enforcement. Um, but we shall see on those. I think there are some. I guess we'll
Sorry.
probably come back to it. I'll probably mention it later. But just there's a bunch of. Well, I think later we're going to talk about what else is coming. But there's a lot of cases in the immigration category that I think will be before the court soon. Maybe not this term, but there's some really important cases coming up. You may remember they heard they've heard a few cases on shadow docket temporary basis dealing with some of the deportations, for instance, and there are big questions there that are come back to them. Citizenship. Um,
These admittedly are sort of lumped together to make a category. They're maybe not really a category.
Yeah, sure. And I'll try to speed up. I think I'm going a little slow. Keeping an eye on the clock here. Birthright citizenship, that's a big case. That's going to be argued soon. It's really, really an interesting case. I've got strong views about it. I'll try to be fair about it. So the 14th Amendment says that everybody born in the United States and subject to the jurisdiction thereof, and that's the contested phrase, subject to the jurisdiction thereof, is a citizen. It's generally been understood that that means if you're born here, you're a citizen. And this is what we call birthright citizenship. And that's been kind of the assumption since the amendment was passed after the Civil War. The Supreme Court effectively ruled that that was the case in the early part of the 20th century, in a case involving a Chinese American. Uh, the administration, by executive order, has said that this is a wrong, incorrect reading of the Constitution, and that going forward, from 30 days after that executive order, that if you are born in the United States to parents who are unlawfully present or who are not, or are here just on a visa, not citizens, you do not acquire citizenship. They are arguing that this phrase in the 14th Amendment, subject to the jurisdiction thereof, means that your parent needs to be a citizen, essentially. Um, I, there are some scholars who believe that. I think that is a very much a minority view. And beyond the view of the Constitution, because the court ruled that way 100 years ago, and Congress passed a statute governing citizenship using the same language as the 14th Amendment after that Supreme Court ruling, I think there's also a good argument that even if one had a different view of the 14th Amendment that the statute Congress has adopted requires that anyway. But it'll be an interesting case. It's I think a test for the court on how it approaches originalism and textualism. The gender designation thing is very different. My guess is that in the birthright citizenship case, I think the smart money is that the administration will lose. On the passports one, I would bet the other way. This is about the transgender issues and the administration kind of insisting that passports indicate biological sex. I think the main arguments on this are kind of again sort of animus, discrimination, equal protection. There's an argument also that it's compelled speech that by the administration's insisting on a certain gender designation, you're forcing a person to identify as something they don't believe in, and that's a First Amendment violation. My guess is that this court would be more skeptical of those arguments, but we shall see.
Yeah, that one has been granted, so for
Okay.
sure. But you're right. Fairly recently.
Uh,
And this is the one that I was thinking of when I spoke in error before. And so the tariffs case is the
yes.
case that people keep thinking might get a decision. It's on the merits docket, but it was argued fairly early, and there is some time sensitivity to this, right? So this
Yeah,
is
this is a huge case, hugely consequential. Again, this is one that we had an amicus brief on. Um, the president is out there saying that if he loses this case, it'll be the death of America, the end of the country, a calamity that we cannot recover from. So there's that. We shall see. The arguments I think, went poorly for the administration. I think there's a lot of reason to believe the court may rule against him on this. Uh, there are here multiple levels of arguments. One is kind of a very pure constitutional argument, which is that tariffs are taxes, and Article 1 very clearly says Congress is the branch of government that has the power to set tax rates. The president is imposing tariffs, lowering them, raising them seemingly daily, based on a claim of power under an emergency statute that gives the president power to take emergency measures against certain foreign threats. There's a couple of questions aside from the constitutional argument, just about that statute. One, the statute is called IEPA. Does IEPA even allow for tariffs? It doesn't use the word tariffs. It talks about the president having the ability to respond in a variety of ways. It doesn't specifically say tariffs, so there's an argument that tariffs are just not allowed under IEPA, period. Secondly, does an emergency actually exist in any of these cases? And there are lots of different tariffs in different countries. I mean, is there the kind of emergency envisioned by that statute between the United States and Canada? I think so. There are lots of ways the court could go about this, and they could resolve constitutional questions or statutory questions. And I think most of the questions the administration faces somewhat long odds on.
Okay, so that brings us to the end of our overview of the categories of cases. Greg can get a drink of water. Thank you for taking that all on. Initially, you were supposed to share that with Kim, so that was him taking on twice the work there at the last minute. But if you were keeping score on your scorecard of the emergency docket cases that have been disposed of, that have been decided, you would have realized that the Trump administration has won all of those cases, except Trump v. Illinois, the nationalization of the National Guard one that we spoke about, and that was a fairly recent decision. So up until recently, it was safe to say that the administration was batting 1,000, and that until Trump v. Illinois. But so there you get just a good visual of where these cases are coming out so far.
Yeah, and I'll just say two things
Yeah.
about that. One, yeah, I think sometimes it's portrayed as that because it is this way because this court is kind of reliably wants to come down on the side of a Republican president. I don't think that's quite right. I do think a majority of this court is worried about encroachment on executive power, and so their default on interim cases is often to side with the government, rightly or wrongly. And then the second factor here to keep in mind is that the emergency docket is in large part created by the federal government. They decide what to bring to the court on an emergency basis. And I think they've been pretty deliberate in bringing the cases where they've got the best chance. And in some of the cases we talked about that are on the merits docket or that haven't come up to the Supreme Court yet, they've not sought emergency relief from the Supreme Court, perhaps because they understood that their odds were longer. So there's a little bit of a self-selection here, but it is true, and I think it's significant but overstated sometimes.
Good. Excellent point. Okay, so here's where I want to ask you about how this term compares to terms in the past as far as the number of cases about the executive power on either docket or both dockets, maybe the significance of those cases, and then do you see a difference between how this administration is using the merits docket versus the shadow docket or not? So this graph, which might be small depending if you're watching this on your phone or something, shows this bar graph shows how often emergency applications from the federal government were on the shadow docket for George Bush for 8 years, Barack Obama for 8 years, Donald Trump the first 4 years, Joe Biden for his 4 years, and then so far, just in a calendar year, not yet even a calendar year, for the second term of the Trump administration. Or anything else that you wanted to give us on your sort of like high level overview of how OT 25 is either the same or different from historical terms.
No, I think it's one of the most consequential terms we've had in my lifetime with respect to separation of powers and executive power. And these cases that are coming down this year will tell us a lot about what our government looks like for the next generation. And I think, as I think I tried to suggest, I think there are categories of cases where I think the executive is going to do very well. There are some categories where I think they're going to lose, and there's a pretty broad band of cases where I'm not sure. And there's ways cases can be decided. It's not even just win or lose. Sometimes it's how you win or lose, or what the court kind of lays down as the rule that will be applied later. So there are a lot of cases. They're very significant. We haven't seen executive power cases like this in a long time. Now, part of this is because the administration is very deliberately trying to change the constitutional order. I mean, this is they have been pretty explicit about this. They think the court got a lot of things wrong in the last century, and they believe the president has more power under the Constitution than has been allowed to the office. And so they are deliberately challenging a lot of existing precedents, and so we see a lot of things in court. And we'll see how it comes down. Of course, the ideological balance of the court has changed a lot in the last 15 years too. So some cases seem ripe to challenge that might not have seemed ripe to challenge a decade or two ago. So it's an aggressive administration. They're pushing claims aggressively. The other thing about the shadow docket is, part of the upswing in all the use of that is how aggressive this administration has been in challenging so many conventions, and lots of previous administrations wouldn't want a legal fight. A lot of these fights are fights that they created deliberately. They didn't like come off accidentally. They weren't trying to avoid litigation. They were seeking litigation. And the other thing that I think drives some of these emergency applications was the historic rise of something called national or universal injunctions, which has been ended now, but it kind of started 20 years ago and really exploded over the last 15 or so years, which is where a decision in a single court in, say, I don't know, Indiana would rule something the federal government had done was unconstitutional and would pause the program not just in Indiana but in the whole country, and that would lead the administration to go for emergency applications more often. So we saw this happen a lot with Trump, but also with Biden as compared to previous administrations. And the third maybe is some deliberate decisions being made by the court, which you'll hear more about in a couple weeks if you tune into the next session. I mean, the court has choices about how to handle these things, but I think there are sort of external conditions that explains a bit of the shift to the emergency docket or the shadow docket, if you prefer.
Great. So then we just want you to like take out your crystal ball and tell us what you think, what other cases you think might turn up at the court in the near future. I throw out some possibilities there that, I listen to a lot of podcasts, I do a lot of reading, some things that are being floated.
Yeah.
But what are other things? Or do you have any odds on any of the things that are there? The White House demolition, the arrest of Maduro and bringing to the United States, the dissolution of the Department of Education, which is very near and dear to the hearts of teachers. So
Yeah, no, I mean, I think any of these, I think the Department of Education certainly would be high on the list of something that we can see. I mean, that really again implicates some of the horizontal power struggles that we talked about. Republicans have proposed eliminating the Department of Education almost since it's been created. It has not happened because there's never been a majority in Congress to do that, and this administration kind of just decided, well, they could do it without a law. And that does seem to challenge some basic understandings about how our system works. So, however you feel about the wisdom of the Department of Education structure, I think it raises some real questions. That's a good one to watch. A couple others. I mentioned immigration cases. A couple that are bubbling up. There's cases under something called the Alien Enemies Act, and the Alien Enemies Act is a law from 1790s that allows the president to deport people on an expedited basis with limited review in the case of a war. So I mean, this was imagining like the British are invading, and there are British operatives in Manhattan, and we want to kick them out of the country. Um, the president has said we're at war with Venezuela. This was before we were more or less at war with Venezuela, but he was saying Venezuelan illegal immigration was effectively an invasion and a war, and therefore he could deport people without what would be normal due process. These cases are bubbling up. The administration has lost some of these cases in circuit courts, and eventually they'll come to the Supreme Court. I think there's been decisions in the Fifth Circuit and the Fourth Circuit against the administration. Um, there's also an interesting case where the president is suing all of the federal judges in Maryland for how they are considering immigration deportation cases. And I think, again, a case that we did an amicus brief on, but we've talked about struggles between the executive branch and Congress. This is a real one between the executive branch and the judiciary. That case is bubbling up. They've lost so far, but that may make it to the Supreme Court. The U.S. attorneys, the president has installed a number of U.S. attorneys without Senate confirmation. And targets of prosecutions by those U.S. attorneys have challenged the lawfulness of their appointments, and they've been having some success in court. That might come to the Supreme Court. That would be a very interesting series of cases. Also, one that we're involved in my organization.
someone just asked a question about that in the chat, in the Q&A. So yeah.
And I think all the questions of like vindictive prosecution or politicized prosecutions may come up. Um, Also, some of the kind of things like the law firm executive orders, where the government is trying to punish law firms it disagrees with by not allowing them access to federal buildings or refusing government business to them could raise some interesting issues. So there's a lot else out there.
Good. I don't want to cut you off, but we got to get some Q&A. So I'm going to skip the part I was going to talk about, but I'll just throw out there that the one case that we have a case summary for. So if you really want to do a deep dive with your students on one case, we have a case summary for Trump v. Slaughter, and Emma can put in the chat the link that can take you to this case. It's got tells you, so many of the things that we just talked about. This is the almost 100-year-old precedent that Greg alluded to, and it will just, give you all the information that you need about this case. Okay, so let's get to the Q&A. I'm going to stop sharing so that you can see Greg better. And I'm going to throw you some questions from the list. Oh, we already answered that question. Um,
See, this is where I'm going to miss Kim because she can answer any question. She's a law professor. Their superpower is the ability to answer any question.
well, here's I'll start you out with sort of a general question. Although try to keep your answers short so we can get to some of the other questions. There are too many questions though, so it doesn't have to be super short. How might these decisions ultimately impact the everyday American?
Oh gosh, I mean, well, it depends which one you're talking about, but I think um, a lot of reasons to be worried about, say, the independence of the Federal Reserve. I mentioned that a lot of people are worried about that. I mean, the financial system and the stability of our economy very much depends on that. Some of these cases ultimately have to do with kind of due process. Some of these immigration cases raise real questions about the power of the government. Cases about the military enforcing law. I mean, a lot of these cases have real, you can imagine, real direct impacts. The tariff cases. A lot of the challenges to the tariff cases are being brought by small businesses that are being wrecked not just by high tariffs but by completely unpredictable tariffs. So the president is changing the law effectively by fiat, and it's really hard to do a business that involves trade if you have no idea what the taxes you have to pay this week will be versus next week. So there are a lot of the. I mean, I think you have to go case by case, but a lot of them have very very real world impact.
Awesome. Okay, here's another question on a totally different um vein. How do conservatives, in parentheses, strict constructionists or originalists, square the unitary executive theory when the framers in the Philadelphia Convention were quite concerned about giving too much power to the executive? Example, the power to declare a war to Congress and congressional override of the veto, plus George Washington creating his cabinet, which delegated executive power.
This is I've thought about writing a book on this, so I don't know how I'm going to answer this in shortly. But look, I mean, I think the short answer is there are different kinds of conservatives who see these things in different ways, and like I think of myself as a conservative. I am pretty sympathetic to the unitary executive theory in that horizontal sense, but sorry, in that vertical sense. But horizontally, I'm something of a congressional supremacist. I mean, I think that, and there are different conservatives who feel very differently and believe in a much stronger executive than I do relative to Congress. So some of that answer depends on how we're defining unitary executive. And I think there's also another tension, I think, for conservatives, and this is something between kind of being a legal conservative and being maybe a temperamental conservative. You're talking about this 100-year-old precedent, independent agencies. It's very easy kind of to look at legal theory and think there's no fourth branch of government. This is impossible to have an independent agency. The Constitution doesn't create independent agencies. Doing so is outside of the structure. That's easy to believe as a legal theory matter, but when it's been there 100 years, kind of the temperamental conservatives as well. This is maybe it's not quite right in theory, but we've relied on this and lived with this for generations, and it's been a stable equilibrium, and we shouldn't challenge it or throw it out so quickly. But I think there are tensions there. Um, and I think this is. Sorry, I won't go too much longer, but I do think that some of the conservative sympathies for executive powers are a bit of an accident of history, and I could go into this for a while, but I frankly think part of it is legal conservative thinking really developed at a time when Republicans could only win the White House. Democrats had control of Congress for 50 years, and it was just sort of natural to be more for people on the right to be more sympathetic with executive power because it was more likely to be Republican, and congressional power was more likely to be Democrat for a long period of time in our history.
Well, we'll be looking out for your book, Greg. So we only have 2 minutes left, so I'm just gonna wrap up. I apologize if I didn't get to your question, but I think we actually got to at least one question from everybody who put some questions in. Um, so I do want to mention, because I already sort of pitched it a little bit earlier, that we're doing another webinar on the shadow emergency docket in about 2 weeks. It's a little later time. Our guest legal expert is going to be Steve Vladeck, whose name you might be familiar with because he is the author of the shadow docket. And he's going to talk us through, what the shadow docket is, some significance of cases on the shadow docket this term in OT 25. And also it was on the slide, but we didn't have a lot of time to talk about it. Maybe how the use of this shadow docket could be changing over time. I can't miss the opportunity when I'm in front of teachers to just mention the fact that if you're interested in this kind of thing, you might want to think about applying for our Supreme Court Summer Institute. You can go to streetlaw.org/SCSI, or you can find it all over our website. You can email me. I put my email in the chat earlier. Applications are due on March 1st. If you go to our website, you can also watch a short webinar that Emma and I did that sort of talk you through how to apply. It's very competitive, just put that out there on the table. But if you're here with us this late in the evening, I think you're probably going to be competitive. These are the other cases from this term that we have available. So I show you sort of an example of Trump v. Slaughter, but we have all of these other cases, and Wolford v. Lopez might be available as early as tomorrow. This is me. Please feel free to email me if you're looking for resources. If you have other questions, I'm happy to answer them. That's my job. I am all over the website. You can't miss me. We're a very small organization. And if you want more information on things like this that are going to happen in the future and you're not already subscribed to our email list, think about signing up. My guess is you are, or you probably wouldn't have found this webinar. So you're probably already good on that. Okay, well, I definitely want to thank Greg first because he was willing to do this and was always on board to do this, but then also that at the last minute he had to take up Kim's role as well and not have a chance to even breathe between slides. So thank you so much for again being our legal expert. It's really helpful to have your unique combination of this deep expertise, but also being able to explain it to lay people who aren't lawyers in a really helpful way. So thank you so much, Greg. We appreciate you.
Thank you. Thank you very much. I'm really honored to be part of this, and I hope it was helpful and I was reasonably clear. And you can also find me on our website, Society for the Rule of Law. If I can be helpful to any of the teachers here today, I'd be happy to do what I can. I thank
Great.
you all for what you do.
Yeah, thank you. Yes, and thank you to everybody who took the time after a long day of teaching to join us and offer great questions. So thank you very much and have a great evening. Bye.